Welcome back to the channel. I am Mr. Kelly, your immigration analyst, and today we are covering one of the most important immigration stories of the entire year. If you are a green card holder, a visa applicant, an asylum seeker, a student, or even a naturalized U.S. citizen, this video is directly for you. On March 30th, 2026, the United States Citizenship and Immigration Services, USCIS, published an official alert titled, Update on USCIS Strengthened Screening and Vetting. This is not a rumor, this is not speculation, and this is not clickbait. This is an official government notice that changes how immigration cases are reviewed, approved, and denied across the board. What makes this announcement so massive is that it does not target just one group. It affects green card applicants, employment-based visa holders, asylum seekers, refugees, diversity visa lottery participants, naturalized citizens, student visa holders, and even people who already received their benefits years ago. We are talking about millions of people inside and outside the United States. In today's video, I am going to break down every single change, explain what it means for you and your family, and give you a clear action plan so you are not caught off guard. Make sure you watch this video all the way to the end, because the last section contains urgent deadlines that could expire in just a few days. Before we begin, if you find this information helpful, please hit the like button, subscribe to the channel, and turn on the bell icon so you never miss an update. Let us get started. Let me start from the beginning. On March 30th, 2026, USCIS released a detailed policy update on its official newsroom page. The announcement was titled, Update on USCIS Strengthened Screening and Vetting. In this alert, the agency essentially admitted that its previous vetting procedures were not strong enough. They stated that prior approval processes allowed cases through that should have received more scrutiny. This announcement was issued under the authority of 3 executive directives. Executive Order 14161, signed in January 2025, and Presidential Proclamations 10949 and 10998, signed in June and December 2025, respectively. Together, these directives instructed USCIS to overhaul its entire screening system from top to bottom. The new rules did not come out of nowhere. USCIS had already created a brand new internal unit called the USCIS Vetting Center on December 5, 2025. This center was specifically designed to handle the expanded background checks, social media reviews, and financial investigations that are now part of every immigration case. Think of it as a centralized intelligence hub inside the immigration agency, something that did not exist before in this form. Now let me walk you through the 5 major changes that came out of this announcement. Starting immediately, USCIS is now conducting mandatory social media screening and financial background checks on applicants across at least 14 visa categories. This includes H-1B, L-1, F-1, J-1, K-1, asylum, refugee, green card, and naturalization cases. What does this mean in practice? USCIS officers will now review your Facebook, Instagram, X formerly Twitter, LinkedIn, TikTok, YouTube, and potentially other platforms. They are looking for posts that contradict your application, any connection to organizations on the U.S. watch list, statements that could raise national security concerns, and evidence of fraud. For example, if you claim to be unemployed, but your social media shows you running a business. Financial vetting means USCIS may examine your bank records, tax filings, and money transfer history. If there are unexplained deposits, suspicious transfers, or discrepancies between what you declared and what your records show, your case could be delayed, denied, or referred for investigation. My strong advice? Review your social media accounts immediately. Delete anything that could be misinterpreted. Make sure your online presence matches the information in your immigration file. This next part is perhaps the most alarming change. USCIS has launched a program called Operation Paris, which stands for Protecting Americans by Reviewing and Reinstating Immigration Standards. Under this program, USCIS is going back and re-examining cases that were already approved between January 2021 and January 2025. Yes, you heard that correctly. Even if your green card, refugee status, or naturalization was approved years ago, your case could be pulled for a second review. USCIS has stated that this re-examination involves merit-based reviews, re-interviews, and cross-referencing with updated databases. If the review finds that your original approval was based on insufficient vetting, incomplete information, or any form of fraud, your case could be revoked or referred to the Department of Justice for further action. This is not theoretical. We are already seeing reports of green card holders being called back for interviews. If you received any immigration benefit during that 4-year window, keep your documents organized and be prepared. USCIS has upgraded its biometric systems to provide real-time automatic notifications when a fingerprint or facial recognition match is found in law enforcement databases. Previously, biometric checks were conducted at the time of filing and sometimes not updated. Now, the system runs continuously. If you are arrested, detained, or flagged by any law enforcement agency after filing your application, USCIS will be notified automatically. This system is connected to the FBI, ICE, CBP, and State Department databases. It means there is no longer a gap between what happens to you in the real world and what USCIS knows about your case. Everything is linked in real time. For asylum seekers and certain other applicants, the validity of employment authorization documents has been reduced from 5 years to just 18 months. This means you will need to renew your work permit far more frequently, and each renewal involves a new round of vetting and biometric checks. But it gets worse. USCIS has also published a proposed rule that would extend the waiting period for asylum-based work permits from 180 days to 365 days. This means that if you apply for asylum, you may not be able to legally work in the United States for an entire year while your case is pending. During the public comment period, there was also discussion about potentially halting new EAD applications for asylum seekers entirely, though that has not been finalized. If your EAD expires within the next 6 months, renew it now. Do not wait. Every applicant's file will now go through a final arrest encounter review before any benefit is approved. This involves cross-checking your name, fingerprints, and biographical data across multiple federal databases: FBI, ICE, CBP, the State Department Consular Lookout and Support System, and Interpol records. Even minor encounters with law enforcement, a traffic stop, a dismissed charge, or an old warrant, could trigger a flag. If your record is flagged, your case will be paused until the issue is resolved. This applies to all pending applications, not just new filings. Now let us talk about the asylum freeze. On March 30th, 2026, the same day as the vetting announcement, USCIS also partially lifted the blanket freeze on affirmative asylum cases. However, this only applies to applicants who are not nationals of the 39 designated high-risk countries. These 39 countries include Afghanistan, Burkina Faso, Burma, also known as Myanmar, Chad, the Democratic Republic of Congo, Equatorial Guinea, Eritrea, Haiti, Iran, Iraq, Laos, Lebanon, Libya, Mali, Mauritania, Moldova, Niger, North Korea, Sierra Leone, Somalia, South Sudan, Sudan, Syria, Tanzania, Venezuela, Yemen, and several others. If you were born in, are a citizen of, or have resided in or traveled through any of these countries, your case remains frozen with no timeline for resolution. For applicants from non-high-risk countries, USCIS has begun rescheduling asylum interviews. However, processing times have expanded dramatically due to the new vetting procedures. Expect interview scheduling to take anywhere from 3 to 12 months. If you are from one of the frozen countries and your case has been pending for more than 2 years, attorneys are now recommending you consider filing a federal lawsuit known as a mandamus action to force the government to adjudicate your case. On April 23, 2026, the New York Times, NBC News, and The Guardian all reported that the Department of Justice has identified 384 foreign-born naturalized U.S. citizens for potential denaturalization, meaning the government wants to strip them of their citizenship. This is the first wave. According to the reports, the DOJ is targeting individuals whose original naturalization is now believed to have involved fraud, misrepresentation, or insufficient vetting. Denaturalization is a civil process, not criminal, which means the government does not have to prove its case beyond a reasonable doubt. It only needs to show that citizenship was illegally procured or obtained through concealment of a material fact. Here is the critical part. If you are denaturalized, you lose your U.S. citizenship and revert to lawful permanent resident status, or potentially become deportable if your green card was also based on the same underlying fraud. The government does not provide you with a free attorney in civil denaturalization proceedings. You must hire your own lawyer. If you became a naturalized citizen between 2021 and 2025, please review your original application with an attorney to make sure there are no discrepancies, omissions, or errors that could be used against you. Let me now cover the April 2026 Visa Bulletin, which contains some significant movements. For employment-based categories, EB2 for Rest of World, Mexico, and the Philippines is now current, meaning there is no wait. EB2 for India has advanced to July 15, 2014. EB3 for Rest of World and Mexico has moved forward to June 1, 2024. EB1 for India and China has advanced to April 1, 2023. For family-based categories, F2A, which covers spouses and minor children of green card holders, has a filing cutoff of February 1, 2023. F1 has advanced approximately 7 months. Now here is the urgent deadline. On April 24, 2026, USCIS announced that starting with May 2026 filings, all employment-based adjustment of status applications must use the final action dates chart, not the dates for filing chart. The dates for filing chart has more generous cutoff dates, meaning more people are eligible to file. By switching to final action dates, fewer people will qualify. This means that April 30, 2026, just days from now, is the absolute last day to file your adjustment of status application using the April dates for filing chart. If you miss this deadline, you may not be able to file again until October 2026, when the next fiscal year begins. If you are eligible, file immediately. Do not delay. Effective January 1, 2026, USCIS raised fees across multiple form categories. Then on March 1, 2026, premium processing fees increased again. The I-140 premium processing fee rose from $2,805 to $2,965. On top of higher fees, USCIS is dealing with a record-breaking backlog. As of early 2026, the agency has approximately 11 to 12 million pending cases, the largest backlog in its history. Average processing times are as follows. Form I-130, the family petition, is taking 12 to 18 months. Form N-400, the naturalization application, is taking 5.5 to 10 months. Form I-485, the adjustment of status application, has processing times that vary widely depending on the service center and category. The new vetting requirements will almost certainly make processing times even longer. Plan accordingly. There are several other important developments that tie into this story. Student visa refusal rates hit 35% in 2025, up from 31% in 2024. Total legal immigration declined by approximately 250,000 visas in fiscal year 2025. This trend is expected to continue or accelerate in 2026. The Customs and Border Protection Biometric Entry-Exit Program expanded on December 26, 2025. Facial recognition scans are now mandatory for all non-U.S. citizens at ports of entry. This adds time to your travel, so plan accordingly. The Diversity Visa Lottery was paused on December 18, 2025, under Policy Memo PM 602-0193. There is no announced timeline for when it will resume. If you were selected for DV 2026, your case is currently on hold. The U.S. citizenship test was updated effective October 20th, 2025. The test now includes 128 possible questions. Applicants must answer up to 20 questions and get at least 12 correct, up from the previous format of 10 questions with 6 correct. The Department of Labor has proposed a rule to increase H-1B wage levels, potentially raising employer costs by approximately 33%. If finalized, this could price many employers out of the H-1B program entirely. Here is what you should do right now. If you are eligible to file adjustment of status, do it before April 30th, 2026. This is non-negotiable. After that date, USCIS switches to final action dates, and your window may close. Review and clean your social media accounts across all platforms. Make sure nothing contradicts your immigration file. If you are a naturalized citizen approved between 2021 and 2025, audit your N-400 application for any errors or omissions. If you are an asylum seeker, check whether your country is on the 39-country high-risk list. If your case has been pending over 2 years, consult an attorney about mandamus options. If your EAD expires within 6 months, file for renewal immediately. The new 18-month validity means renewals come faster. If you are traveling internationally, plan extra time at the airport for biometric screening at all ports of entry. Consult a qualified immigration attorney. You can find one through the American Immigration Lawyers Association at AILA.org, find an attorney, or through lawhelp.org for free or low-cost legal services. Keep these numbers and websites saved on your phone. USCIS Contact Center, 1-800-375-5283. USCIS Case Status Online, egov.ucis.gov IRS. Helpline, 1-800-829-1040 United We Dream. Hotline, 1-844-363-1423. ILA Attorney Finder, ILA.org, find an attorney. That is everything you need to know about the new USCIS rules announced in 2026. This is real, this is happening right now, and millions of immigrants are directly affected. If this video helped you, please hit the like button, share it with anyone who needs this information, and subscribe to the channel with the bell icon so you are the first to know about every new update. Drop a comment below telling me which change concerns you the most. I read every single comment. This is Mr. Kelly, your immigration analyst. Stay informed, stay prepared, and I will see you in the next video. Take care.